there are three possibility retrospectivities. Look at the consequence. Whether the Lordship doesn't hold it to be without the consequence. Three. One is, it is retroactive from the date the Shiv Sena was recognized as a 29A political party. That was in 1990 or 92. I'm giving you three alternatives. I'm not... because today I am the Election Commission, I hold that this is the Shiv Sena. If it is retroactive, logically it should go to the date when 29A. But let's leave that. Second, it goes back to 21st June when this action started. And third, it goes to 19 July when the petition was filed. There are only three possibilities, Malus. Forget everything else. I'll take one point here is enough. Malus, whatever else your Lordship holds, on the bare text, textually and facially, symbol order number 15, has to be prospective, Malus. Forget all the, we'll come to the interpretation. Just read the text facially. That's at para 15A of my note.
Yes.
Without anything more. We'll come to the consequences. Well, as drafted facially, without any interpretation, it has to be only prospective. Kindly read. Power of the Commission in relation to splinter groups. Now, I've underlined some words. I've taken the liberty of underlining some words. When the Commission is satisfied on information on its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the Commission may, after taking into account all the available facts and circumstances, and hearing such reps of the sections or groups and other persons who desire to be heard, decide that one such rival section or group or none of such rival groups shall be binding. Well, this cannot but be futuro. Number two, look at the consequences of holding otherwise. There will be very, very strange consequences. Two things, Malus. If your Lordship were to hold the 19th July, that's the date, order of the EC.
17th February.
Sorry, 17th February 23. I'm sorry, 17th February. Petition is filed on 19th July. 17th February is the order. Now, Malus, the order to be retroactive, question number one, retroactive from when? Now, Malus, a very strange argument was raised, de facto doctrine. Regularization and validation by 189. Mr. Salve argued at length. Mr. Mehta also argued,
Page
I believe.
189, I'm sorry to interrupt. What is 189?
No, page 1.
Page 1 of my note. That is, Malus, the de facto doctrine that actions validated by the actual act, which is challenged, is illegal. I want to show, Malus, how wrong this can be and how dangerous it is. Give me just 2 minutes. Resignation.
The act of resignation.
Act of resignation. The most important thing is it's a prior challenge. The illegal act of the governor is a prior pending sub judice challenge before the trust vote.
So you are really saying that Mr. Uddhav Thackeray resigned only because he was called upon by the governor to face a trust vote?
I'm grateful. After I had filed a petition, after I had made it sub judice, and after I had said this is completely unknown to law, don't allow it to go on.
And you are frankly accepting the fact that, well, you resigned because the trust vote was going to go against.
When you do an illegal act, the consequence of that is known to me. The CM's participation or absence of participation would not dilute that fundamental illegality. If it's illegal, it's illegal. How does my non-participation validate the act of the governor? Is the core question. That's the correct legal answer. In law, since the illegality of 28 was already sub judice, so prior is important, and pending in a court, a participation or absence of participation of ex-CM could not possibly affect the prior illegality, which is already sub judice. Now, as an example, if one, this is very important, if one were to assume that I had subjected myself to the trust vote, the ex-CM had subjected himself on 30th and lost, and after losing challenged the trust vote, it would make no difference in law because the trust vote was merely the consequence of the illegal act of the governor, and the challenge would still relate to the governor's actions and not to the trust vote. The participation or absence of the ex-CM has no relevance. I'm not troubling with A3, my submissions A to N are giving the law ibius, meaningful, status quo ante, scrambled egg, fait accompli, all that is given with law, Malus, in that. Kindly, Malus, do me the favor of treating it as having stated here. Now, just this is very important. This has not been shown to your Lordship. Just give me a minute. 398 and Malus, 5 judges out of 9 say this. 5. First is Justice Malus Jeevan Reddy, with Justice Agarwal, the proclamation must therefore be held to be not warranted by Article 350 outside its purview. Cannot be said that the President was satisfied that the government of the state cannot be carried on. The action was malafide and unconstitutional. The proclamation is accordingly liable to be struck down. And we would have struck it down, but for the fact that elections have since been held and a new assembly has come in. That's the only exception. Today, the illegal government is running. There is no elections. Then, and the person who otherwise, suppose the Lordship holds the governor to be bad, then a person not entitled to be holding the post, hold the post of Chief Minister. How can, of all courts, the Supreme Court accept such illegality? If your Lordship's powers are unique in this country, in that even your Lordship's can go beyond the law. Not contrary to law, beyond the law. Then, what's the point if the governor's actions are held to be illegal? Actually, your Lordships would be giving a Parik declaration and accepting that the illegality has borne the fruits of its illegality and people have enjoyed it. Therefore, this is the heart of this point. Now, a very strange argument was raised, de facto doctrine. Regularization and validation by 189. Mr. Salve argued at length. Mr. Mehta also argued,
Page
I believe.
189, I'm sorry to interrupt. What is 189?
No, page 1.
Page 1 of my note. That is the de facto doctrine that actions validated by the actual act, which is challenged, is illegal. I want to show how wrong this can be and how dangerous it is. Give me just 2 minutes. There are two kinds of challenges. One is a challenge to the very validity of the act. Come to para 8 of my note. So I challenge a validity of an act. Let us say the Governor's Act. Let me say competence of a legislation. Let me say fundamental rights. Versus the eligibility of certain people to act under the act, to sit there and act. Your Lordship under 189 protects the second, not the first. If the governor's action is bad, will 189 ever protect it, Mr. friends, two of them argued at great length on 189. Did they answer the question? Ultimately, the core question, my Lord, is just formulated either way, this way or that way. Is the governor valid or not valid? If your Lordship holds him to be invalid, 189 comes only after your Lordship holds something to be invalid. Otherwise, it doesn't come into play.
It is said in the context of the vote in the House.
So,
with respect to...
Exactly. So, therefore, no. 189, your Lordships can and may, and in this case, perhaps should, in the intervening period of 7-8 months, the decisions taken by an otherwise illegally constituted government may be valid under 189. That's the real commonsensical way of implementing it, I am not suggesting that somebody's appointment is quashed, somebody's transfer is gone, somebody's policy decision.
So what you're really saying is,
liquor policy, therefore that is gone.
Saying is that Article 189 recognizes a de facto doctrine.
De facto doctrine.
What the de facto doctrine does is to legitimize the acts of an authority whose original appointment is found to be invalid.
Subsequently found to be
invalid. Correct. But that does not validate the original appointment itself.
That's the one sentence pithy summary. Just give me a minute. Come to D, 8D. Or calling for, that goes back to the same thing. First act was what? The governor being approached, governor calling. The two others are consequences. Voting is a consequence of the governor's illegal act. So is the oath taking. If the original act is bad, and your Lordships can't validate it, then this will not validate the vote. The consequence is bad. The consequence of an illegal origin cannot validate the illegal origin. And similarly, 189 cannot...
What you're saying is that if the calling of the voting in the House itself is subject to...
Just how my Lord's formulation was, right or wrong, governor's action, A, no basis, and B, if basis, it is wrongly applied, etc.
But that's the affirmation of the House, right? Then what? I mean, I still have it.
Affirmation is coming. That's this section. Bommai dealt with the affirmation.
All right.
Bommai said, we hold something to be illegal. Let's kindly give me a minute. This is very interesting. But thereafter, Parliament has approved it. Exactly the same thing. How can we quash it? Said, no, sorry, you will be quashed. Can you come to that now? Much worse, fellas. Here there was nothing. In our case, there's nothing. There was a presidential proclamation affirmed by Parliament in Bommai that if a proclamation on 350 is invalid, the same as liable to be set aside even if it has been subsequently approved by both houses. Your Lordship is told 189. This is express approval. This is express approval. Now read this para. Very interesting. 110 Justice Sawant for Justice Kuldeep Singh.
We'll check this up. We got the point. I mean, you're saying that the Bombay has a...
Now, there is one interesting, very interesting, after 29 years and 2 days, this is happening in a Lordship's court. This para 110, that bold-face line by Justice Sawant says invalid. Lordship got the second line underlined.
Yes.
All the books say it's valid. SCC. SCR correctly says it's invalid. SCC for 29 years and 2 days called it valid.
I hope you're citing our ESCR, Dr. Singhvi.
No. We've checked up. Then they issued a corrigendum. When my learned friend's colleague here, sitting here, pointed it out, then the SCC issued a corrigendum.
I must also publicly acknowledge there was a glitch in our ICT infrastructure overnight. My team was working till 5:30 in the morning. They began working yesterday.
Oh, I see.
They left for their homes at 5 o'clock in the morning, 5:30 in the morning, to ensure that, we are all
it's very creditable.
we are ICT enabled.
It's very creditable.
And unlike the private sector, they wouldn't get even a rupee worth of bonus. It's just a love for the job that they do it.
The time, money.
Private sector is education.
Your Lordship is entitled to judicial right.
Batao. You are part of them.
No, this is just an aside. The word
saying private sector or senior counsels, I said. Chief is saying
some of your lordships, most of your lordships.
I told my learned brother, you are part of them too.
Complete estoppel.
Estoppel, that's why I didn't say.
And a very recent estoppel, relatively. Now, the word invalid here is by corrigendum, the correct word. It is in the SCC valid. So it can't be valid. Just note that. What is the legal consequence of actions taken by the President if the proclamation is invalid, yet it is approved by both houses? Come to 111 Lordship and see I am racing only on the underlined portions. The proclamation will not make any difference to the legal status. Express approval. Forget 189. Parliament expressly approves. Necessary constitutional fallout.
Get the point.
Unless such result is read, the power of judicial review is nugatory and meaningless.
There is a constitutional permissible, it's permissible to have a complete restitution, is what you're saying.
Otherwise, it's meaningless and nugatory. The 9 judges say that, and next sentence highlighted. Hence, the necessary consequence of the invalidation would be the restoration of the ministry. Clearly, para after para is devoted by Justice Sawant and Justice Kuldeep Singh. And just see 7, another phrase, molding of relief, big Roman 7. Otherwise, what's the point your Lordship is exerting so much, if your Lordship comes to that conclusion with great respect? And that to a court with 141, 142 and special powers. I can understand the High Court possibly flinching. According to me, even the High Court has the power to do it under your Lordship's judgment. Look at these words, 9 judges, 29 years ago.